All right, this will be the Magistrate Court of DeKalb County Ordinance Division. I'm going to go ahead. This is a 2 o'clock failure to appear calendar. I'm going to go ahead and handle these real quick. Alan Gordon. Mr. Gordon present? Come on up, Mr. Gordon. All right, sir.
Raise your right hand. Swear firm testimony to give you the truth, self you got.
I do.
State your name.
Alan Gordon.
All right, Mr. Gordon, you're representing yourself today.
Yes, sir.
You wish to proceed without being represented by counsel.
Yes, sir.
You negotiated the resolution of your case with the solicitor's office.
Yes.
And the negotiated resolution involves you entering a plea to citation 176-92634. And that is a charge of loitering. You're entering a plea of guilty. You're agreeing to pay a $50 fine. And you're able to pay that fine today?
Yes, sir.
All right, so is anybody forcing you to enter a plea today?
No, sir.
Are you freely and voluntarily giving up your right to have a trial on the charge?
Yes, sir.
Are you under the influence of any drugs or alcohol at this time?
No, sir.
Accept your plea as being freely and voluntarily given. Sentence you as stated. You can pay the cashier on the way out, sir. Thank you. Shaka Ryder L. I apologize if I'm mispronouncing that. Shaka Ryder L.
Raise your right hand. Swear firm testimony to give you the truth, self you got.
Yes.
State your name.
Shaka Ryder L.
All right. And you are representing yourself today.
Yes, sir.
You wish to proceed without being represented by counsel.
Yes.
You negotiated the resolution of your case with the solicitor's office.
Yes.
And the negotiated resolution involves you entering a plea of nolo to the charge of open container. You're agreeing to pay a $50 fine
Yes, sir.
as to that. And we're going to put you on the deferred sentencing calendar. Let's see. How much time do you need, sir?
Not long at all.
Well, would March 2nd be enough time?
Yes, sir.
Okay, we'll put you down for March 2nd, man. Give you time to pay that fine. Is that your understanding of the plea?
Yes, sir.
Is that how you want to proceed?
Yes, sir.
Is anybody forcing you to enter a plea today?
No, sir.
Are you freely and voluntarily giving up your right to have a trial on the charge?
Yes.
Are you under the influence of any drugs or alcohol at this time?
No.
Accept your plea as being freely and voluntarily given, sentence you as stated. And then as to the second offense, that is being dismissed. All right, sir?
Yes. Thank you.
Just have a seat, and we'll have a little more paperwork for you related to the deferred sentencing case, okay? Joel Quinones, I apologize. All right, sir.
Raise your hand. Swear firm testimony to give you the truth, self you got.
Yes,
State your name.
Joel Quinones.
All right, Mr. Quinones, you're representing yourself today.
Yes, sir.
You wish to proceed without being represented by counsel.
Yes, sir.
You negotiated the resolution of your case with the solicitor's office.
Not entirely.
Whoa.
I would like to request the FTA fee be waived, and possibly, if possible, the fine to be reduced.
So, well, talk to me about why the FTA fee ought to be waived.
I was not able to make it to court because I was incarcerated at the time in Gwinnett County.
Okay, well, I'll waive the FTA fee based on that representation. Tell me why the fine ought to be reduced.
I just feel it's a little steep, and I have other pressing matters. That's almost a half of a week's salary for me. I just felt it's a little steep.
Well, so I'm not sure you understand this, but possession of marijuana is still a crime.
I understand.
So the scheduled fine for that is $250, $500. So
Okay. If my request cannot be granted, then it's okay. Just
okay, and you're gonna pay that fine today?
yes.
All right. All right, sir. I've waived the FTA fee. I'm gonna leave the fine the way it is. Is that your understanding of the plea?
Yes.
Is that how you want to proceed?
Yes.
Is anybody forcing you to enter a plea today?
No.
Are you freely and voluntarily giving up your right to have a trial on the charge?
Yes.
Are you under the influence of any drugs or alcohol at this time?
No.
Accept your plea as being freely and voluntarily given and send it to your state. Pay the cashier on the way out, sir.
All right.
Joshua McClure. I'm sorry, I couldn't read your handwriting. I was trying to find it. Joshua McClendon. Mr. McClendon, come on up.
Raise your right hand. Swear to testify you give the truth, set together.
Yes.
State your name.
Josh McClendon.
And Mr. McClendon, you're representing yourself today.
Yes, sir.
You wish to proceed without being represented by counsel.
Yes, sir.
You negotiated the resolution of your case with the solicitor's office.
Yes, sir.
Negotiated resolution involves you entering a plea of guilty to the creating a hazardous condition. You're agreeing to pay a $200 fine. You're able to pay that fine today?
No, sir.
I'm sorry?
No, sir.
You're not able to pay it today.
Mm-mm.
Well, it says pay today.
Hmm.
All right. I can put you on probation for up to 12 months. Is that what you'd like me to do?
Yes, or you can just give me a little time. I can come back and pay it.
Okay, well, how much time do you need?
Like a week or so.
Okay, I can give you to March 2nd. Would that do it?
Mm-hmm. Yes, sir.
Okay, I'll put you under deferred sentencing until March 2nd to give you time to pay that fine, okay?
All right.
All right, sir, is anybody forcing you to enter a plea today?
No, sir.
Are you freely and voluntarily giving up your right to have a trial on the charge?
Yes.
Are you under the influence of any drugs or alcohol at this time?
No.
Accept your plea as being freely and voluntarily given and send it to your state. Just have a seat. We'll have some more paperwork for you related to the deferred sentencing. March 2nd. All right, I believe that concludes the FTA calendar, right? All right, then give me 1 minute. I'll be right back.
Okay, sir, go get him on his way. Come up, sir.
We'll start on the, we'll resume the Avery trial.
Good afternoon, buenas tardes. Si hay alguna persona que necesite ayuda de la intérprete en español, alguien que no hable inglés.
prosecutor turns out I need to testify because I took the truth.
It's not suspended his license. It's just two things this time. You'd be another county. Thank you, sir. Have a good day.
May City Court come to order.
Thank you, sir.
Judge Ms. McCoyd stepped out for just 1 minute. She'll be right back.
We're gonna be in.
Yes.
I just want to put that in anything, they say they don't have it, anything to maintain. It could be in the court.
I haven't checked everything.
Almost all right. Maybe there's a bit count down to the city.
All right, we will pick back up with the Avery trial. Are the parties, is this county or the state ready to proceed?
County is ready, Judge.
Ms. McCoy, have you had a chance to discuss with your client his option of testifying or not testifying?
Yes, Your Honor, I would like the court, though, to make inquiry into what he has decided.
Yes, ma'am.
It is my representation or my advice that he should not testify. I believe for him to do so is detrimental to his case. And for me to agree to him, to recommend him testifying would be ineffective assistance of counsel.
I understand, so you are on the record that you have advised him he should not testify. Mr. Avery, have you considered whether you are going to testify or not, sir?
She's afraid I'm gonna tell the truth, so I guess I'm gonna say no.
So you have a right to testify.
I want to.
You have an absolute right not to testify. I understand you've elected not to testify.
She's afraid I'm gonna tell the truth.
You've elected not to testify. I understand you've elected not to testify. That is consistent with your counsel's recommendation. Is there any other evidence that the defendant would like to present?
May I inquire onto the record briefly regarding this not testifying? Mr. Avery, is it your decision not to testify?
Well, it's actually,
Is it
on
your-
your advice, yeah, that's it, on your advice.
You understand that you do not have to take my advice,
I do.
that you can go
But I
forward
also
and
understand
testify
you
if
have
you
a
want.
question you need to be asking me.
Mr. Avery,
Okay, no, I'm not gonna testify.
I need you to answer your lawyer's questions, okay? She's asking you questions in a very nice, polite way. I'd like you to respond in the same way. They're simple questions.
Okay.
I'd like you to answer her questions.
No, I'm not gonna testify.
No, I want you, let her ask you the question and then you answer it.
Mr. Avery, you understand you do have a right to testify.
Yeah,
You understand that even if I have expressed my opinion that it is not in your best interest to testify, that you still may testify.
but that may, yeah.
And you are deciding not to testify at this point in time.
I'm thinking about, yeah.
And there have been no threats or coercion by myself to prevent you from testifying, correct?
It's a matter of opinion, but I would say yes.
I have not threatened you, correct?
Certainly, it's a matter of opinion, but no.
Okay. I have not coerced you, correct?
Yes.
I have coerced you?
No, you have not.
Okay. And so this decision is your free choice, correct?
Yes.
All right.
All right. Is there any other evidence the defense would like to put on?
No, Your Honor.
Okay, do we have any closing argument?
Leave the state goes.
Judge, state has the burden, we would reserve for final.
Okay.
This isn't a trial.
Well, but Judge, we
I'm-
still have the burden.
I'm affording the parties an opportunity to give closing argument.
Your Honor,
And the county does have the burden. I mean, and they do have to meet the burden.
Your Honor, we're asking the court to dismiss this petition. The state has alleged various reasons for Mr. Avery violating his probation. And I am not going to take this in order. And first, one that I would like to address is the state has indicated that he failed to avoid injurious or vicious habits, but with the especially illegal drug use by admitting to using and abusing methamphetamine. Your Honor, in this incident, the only evidence that we have is through Mr. Avery's probation officer, Mr. Davis, that Mr. Davis indicates that Mr. Avery has used methamphetamine. Well, I understand that the case law permits defendant's statements alone to be used as a grounds for violation. I believe the court needs to take these statements with a grain of salt. As the court has interacted with Mr. Avery, as the court has seen from his actions, Mr. Avery is an attention seeker. And Mr. Davis even admitted that Mr. Avery does seek attention, whether it is positive or negative. Your Honor, in this case, Mr. Avery is not a reliable indicator as far as whether or not he is using methamphetamines. We are only going by someone who is out to seek attention. In regards to the failure to undergo substance abuse, Mr. Avery made 2 attempts to get a substance abuse evaluation. The first one where he reached out to care and counseling, they declined to do so, which is their right. They then referred him to 2 other places. He then made an appointment and kept his appointment with the Atlanta Alternative Services. At that point in time, he got there and they refused to evaluate him for drugs because they thought he was high. He was there, he was willing. Again, there has never been any tests, any drug tests that he is actually using methamphetamine. Same with that situation. Unfortunately, the individual who refused was not here to testify, but we do know that from what Mr. Davis has said. In regards to the allegation that he failed not to violate the criminal laws of any government unit by creating a hazardous condition and attractive nuisance with signs, puppets, and other decorations. Your Honor, we understand that his neighbors don't like him. That has been abundantly clear that his neighbors don't like him. As far as creating a nuisance and a hazardous condition, there has been testimony that there has been quite a bit of traffic and slow-moving traffic. However, when Mr. Bliss testified, he also testified that that slow-moving traffic that he was referring to occurred during rush hour, when there was slow-moving traffic because of the volume coming from Emory up to Claremont. There have been no accidents, there have been no citations for Mr. Avery for disruptive behavior, disorderly conduct, anything along those lines. Mr. Avery does have a First Amendment right to express himself. We might not like what he says, his neighbors may not like what he says, the court may not like what he says, but he does have that First Amendment right. That was addressed actually during the trial as far as whether or not he had a right to express himself, and therefore the court only found him guilty at that point in time because of the numbers of signs, not the contents of the signs. The attractive nuisance regarding this puppets and other yard decoration, Mr. Davis testified that he had been out to see Mr. Avery on numerous occasions. That since the time when he was first put on probation back in January. In addition, Mr. Bliss testified that things such as puppets have been out there on a daily basis for several years, far beyond the year that Mr. Avery has been in front of this court. As Mr. Davis testified, we came here at least on 2 other occasions prior to the petition to revoke him. We came in April and I believe in July. At both times, when this artwork was out there, probation testified and code enforcement testified that Mr. Avery was in compliance. In perusing the statute, as far as for the definition of an attractive nuisance, in the code section there is not a definition for an attractive nuisance. If you look into other parts of the code section when it comes to defining nuisances, it is clear that what the code section is referring to are things where there's an actual danger. A nuisance, a pool being left open and unintended, siding coming off a house, garbage in a house that creates a health hazard. In this case, his neighbors don't like looking at it, but it's not out of compliance with anything. He has a right to express himself. In regard to the violations of the code section, the occurrence on, I believe it was the December 2nd, where he was charged with obstructing a right-of-way. There was testimony presented that there were puppets in the middle of the sidewalk. There was no testimony whatsoever that Mr. Avery admitted to those puppets being his. There was no testimony that anyone saw him put those puppets there. The code enforcement officer testified that they had previously seen one of the puppets in the yard, and then they saw it on the roadway, on the sidewalk. However, that does not necessarily mean that Mr. Avery put that there. There's been no evidence offered whatsoever to address that. In regard to the amount of signs for the January 27th, and the court has those pictures to see, Mr. Avery has 4 signs that are facing outward that have his message on them and what he is trying to communicate. Allegedly, there are signs that face towards his house. I believe that's what the officer said. However, there's been no evidence to any writing on those signs. There's been no evidence that there is any signs on the backside.
So hold on a second. Because Mr. Avery has a First Amendment right.
Right.
And we're not going to judge the content of any signs.
I'm not saying the content.
And so if I'm not speaking to content.
I agree that.
So
I understand that.
It's got to be content neutral. So if the content is a white space, I'm not going to distinguish based on content.
What I am talking about right now is in the January event, we have, this is the part that's facing the street.
I understand.
And then we have another that's facing the back. We do not have any evidence that there is a sign there. There's no evidence that there isn't anything beyond a backing.
So I am not going to judge the content. I am, because you're asking me to distinguish between signs that have printed words on them and signs that have white space, and that's content. And I'm not going to judge whether that is content qualifies as a sign or not.
I understand what you're saying, Judge, but and I may not be making myself clear in this case. the purpose of the sign ordinance, from what I understand in my reading of the code and being in front of this court, has to do with avoiding clutter. And there's an aesthetic aspect to it, that the county does not want a property filled with signs. They want to limit the amount of space that is used and limit what is visible to passerbys and that sort of thing. The one that I am talking about, I'm not talking about the one where there's 5 signs and two of them may or may not be a sign. That would be a different.
I understand. Okay. You're just on January 27th.
Right, where
understand.
you have a sign that is facing, and then you have what the officer has testified it's a sign, but there is no evidence that it is a sign. There's nothing facing the street. There's no pictures regarding what may or may not be there. There's no evidence that what we're talking about is not the backing of the sign that he has.
I understand your argument.
And so that is my argument with that date. In regard to the September 9th, where we have the 5 pieces of paper that are displayed. The definition of a sign is something that communicates meaning. There's been no testimony that...
But I'm not going to get into the content. And so an artist, there are plenty of artists who would say the negative space is just as expressive as the positive space. And so if you're displaying a blank page, I'm not going to judge whether that is artistic speech, protected First Amendment speech, or not, because that's not my place. It is a sign.
But what I am saying is there has been no evidence to prove that that is a sign, that was meant to convey any sort of meaning.
I don't think any evidence is necessary. It's because I'm judging its content if I look to see what its purported meaning was. And I'm not going to let...
Any meaning. Now, I'm not asking the nature of the meaning. I'm talking about whether or not there is meaning.
Well, I don't know. I think it's not my place to judge whether on October 31st, 2017, the placement of a 2x3 sign with markings on it next to a blank 2x3 sign, next to one with markings, next to one that's blank, next to one with markings, that alone might be artistic or speech or intended to be speech. And I don't believe it's proper for me to delve into that, and therefore I think I have to treat it as any other, that it's a sign.
In order for the state to prove the revocation, they do need to prove by a preponderance of the evidence that that meets the definition of a sign, that was placed there to convey meaning. I'm not asking that you go into the content of what that piece of paper.
I think it's pretty clear it was placed there to convey meaning. The question is what meaning?
I don't think.
Because I think it was placed there by Mr. Avery as a big sign to the county.
However, there has been no.
And I think I know what the meaning of the sign is. And they've introduced the photographs.
Yes, they have.
And the act speaks for itself.
And we would disagree, Your Honor. But
I understand.
That is what my position is.
I understand.
No further argument, Your Honor.
Mr. Kemp.
Judge, I'm going to take this a little bit out of order too, and I'll try to be brief as I know how to be. Judge, regarding the sign issue, there are photographs introduced as evidence before the court from September 9th, from October 31st, from November 1st, from December 2nd, all from 2017, and also from January 27, 2018. Judge, the photographs from December 2nd, 2017 speak more towards the obstruction on the sidewalk than they do the signs, and that was Officer Brown's testimony before the court too, Judge. But the violation of the sign ordinance specifically applies for September 9th, 2017, and for January 27, 2018, because Officer Brown testified that in her training and opinion as a code enforcement officer, they exceeded the 24 square feet by aggregate, which violates the sign code. Judge, again, no one is here to speak to content of the signs. But these placards, they're signs, and they convey a visual message. What that visual message is, I don't know. But it does convey a message, Judge. And by conveying the message, it is a sign underneath the DeKalb County Code. Also, Judge, if you look to the definitions of our sign ordinance, and that is under, or excuse me, I should say the legislative purpose, and that is under 21-1 of the DeKalb County Code, without going through all of the individual purposes that are enumerated there. The first one is to protect the health, safety, and general welfare of the citizens of DeKalb County. And some additional language there, Judge, to implement the policies and objectives of a comprehensive development plan in the county through enactment of a comprehensive set of regulations governing signs in DeKalb County. Judge, if you look to, excuse me,
Position, well, subparagraph number 3.
you do, Judge.
Purpose, to preserve the value of property on which signs are located and from which signs may be viewed.
Yes, Judge, but I was even going to direct the court down to position 12, which is to place reasonable controls on non-conforming signs, that they are by definition contrary to the public health, safety, and welfare, while protecting the constitutional rights of the owners of said non-conforming signs. And Judge, the county code also speaks to free speech rights. So Judge, underneath the United States Constitution, the Georgia Constitution. So again, this isn't a matter of content. This is time, manner, and place. This is just a matter of how the sign ordinance is to be enforced. And based upon the testimony of Officer Brown, based upon the testimony of Probation Supervisor Davis, the county's established by a preponderance of the evidence that James Avery violated the DeKalb County ordinance, the sign code, both on September 9, 2017, and again, we think on January 27, 2018, and we believe that James Avery also violated the restrictions under the sign code, not because of the aggregate sign issue on December 2nd, 2017, but because of the obstruction of the sidewalk, Judge. And you heard that Officer Brown testified that that object was previously seen in James Avery's yard. It was found right in front of James Avery's yard. It was placed there in front of the signs, which were also present, Judge. And it is a logical inference by preponderance of the evidence that that was placed there in violation of the sign ordinance. So, Judge, regarding the sign issue, the county would use its burden by a preponderance. As for the hazardous and offensive condition, Judge, the code specifically speaks to a hazardous or offensive condition that serves no legitimate purpose, an act which serves no legitimate purpose. And again, we're not asking the court to delve into content, but there is no legitimate purpose in the way that the act by Mr. Avery and the way he's displayed things in his yard has implicated public safety, quiet use and enjoyment, traffic control.
Oh my God!
Tell me, I want to even hear it.
Sorry.
Sorry.
I want to even hear nothing but tell it.
Okay.
So then,
Can you?
okay.
Oh.
Oh, okay. So way too loud?
It's not static.
No, well, let me go.
Is it too loud?
Well, for me it is, but I'm not saying it's
Can
not.
you hear me, Mr. Avery? Mr. Avery, can you hear me?
No.
All right, well, it's,
Ain't nothing but tell it.
Do you have?
Well-
Take your other
I hear you
hearing
now.
aids out.
I have one in and one out.
That's why you're hearing the static.
Well, I needed to hear other stuff, Judge. I have no reason to do it that way. Trust me. Now everything's working. It's working now. I hear me at least anyway.
all right, well, can you hear me? Great.
Hit stop.
All right, go ahead, Mr. Kemp.
Thank you, Judge. So if we go back to the DeKalb County Code, creating a hazardous or offensive condition, an act which serves no legitimate purpose. Judge, as I was speaking to Mr. Avery's act from his yard decorations, his yard art, his signs, the sock puppet monkeys, the lamps, everything that is in his yard, Judge, it serves no legitimate purpose. Again, not speaking to content, but speaking to the fact that he has impeded traffic flow. He has, as Charlie Bliss testified before the court, turned that sidewalk into a ghost town that people do not want to walk in front of James Avery's home. That when there is heavy traffic from Emory coming through the area, James Avery makes himself a spectacle before those motorists. And Judge, what I think is an important distinction about the traffic from Emory and the traffic that is there to see what Mr. Avery has in his yard is that you had multiple witnesses testify to the fact, both Supervisor Davis and you had Mr. Bliss testify that motorists stop. They put on their brakes, they gawk, they check it out, they have pedestrians stop, they look. They are clearly there to see what is going on in Mr. Avery's yard. And Judge, because there's no legitimate purpose in this display, and because it is creating a public safety issue, it is therefore creating a hazardous and offensive condition under the DeKalb County Code. So Judge, we think by preponderance of the evidence, the county has met its burden regarding that. Regarding the issue of not submitting to a substance abuse evaluation, Mr. Avery came before this court, said that he was going to submit to a substance abuse violation or evaluation. It seems clear that he has not done that. You've heard from multiple witnesses that he did not do so. No evaluation has been tendered to probation regarding any substance abuse evaluation or treatment. That is a violation of his probation, Judge, and we would ask the court find so. As for the issue of whether Mr. Avery is a methamphetamine addict or abuser, we don't know. Now, we used to call this an admission. I guess we still do. He says by his own mouth to anyone who'll listen. He says it on the news. He says it in person. I use meth. I'm a meth user. I'm a meth abuser. But he won't submit to that evaluation, Judge, so we don't know what's going on with Mr. Avery, whether he actually ingests meth or if he's just using it to try and get attention. Regardless, Judge, the admission itself is a violation of probation, but more importantly, it implicates the fact that he has refused to submit to his substance abuse evaluation. Judge, I know the other issue that was before the court in the petition, the court is not going to hear, so of course we're not going to argue on that, Judge. Finally, Your Honor, I've said it before, and I know the court has heard me say it. A probationer does not enjoy unfettered liberty because he is constrained by the sentence of the court. Mr. Avery has a duty to be a good probationer. He has a duty to abide by the terms and conditions of his probation. Not just because it is the right thing to do under the law, but because the law specific to his probation compels and commands him to do so. And Mr. Avery, by his acts, if not also by his words, continues to scoff at probation. Judge, I think what was most telling was the November 1st video that was introduced as evidence and played for the court, where Mr. Avery specifically said, I have 5 signs, I'll be in defiance, I'm only allowed 4. Whether that is a true statement of the law or not, Judge, what matters is Mr. Avery, by his own act and his own admission, knows that he is in violation of probation. He is laughing at probation, and he is laughing at the court, and he is laughing at the citizens of DeKalb County. And Judge, Mr. Avery needs to be held accountable for his bad behavior, and he needs to be held accountable for what he has done, both to the citizens of DeKalb County and to his neighbors. So we would ask that you find he violated his probation by a preponderance of the evidence. Thank you, Judge.
All right. All right, well, first, let me thank counsel, Mr. Kemp, Ms. Voigt. I appreciate both of you trying your case in a very professional manner. You both are excellent lawyers, and I appreciate the good job you've each done. I find that Mr. Avery violated the terms of his probation by violating the county ordinance on September 9th, 2017, and on November 1st, 2017, by having signage in his yard that exceeds the allowable total square footage pursuant to County Ordinance Section 21-13. Let's make sure. Yeah. 21-13, subparagraph 1. Specifically, I find that Mr. Avery was intending to convey meaning by displaying the blank signs in his yard, in addition to the signs that contain printed material. I think they were intended as speech. They were intended to convey meaning. I find that he has violated his probation on those two occasions. The issue about a hazardous and offensive condition, I'm not going to, at this time, I will not find that he violated his probation by creating a hazardous offensive condition. At this time, I'm not going to find that he has violated his probation by failure to undergo drug and alcohol evaluation and treatment. And at this time, I'm not going to find that his statements regarding methamphetamine use constitute a violation of his probation. I leave it open. I think that those are areas that are potential areas for violation of his probation. But having found the violations occurred on September 9th and November 1st, 2017, I find it's not necessary. And so I'm not going to make specific findings as to those allegations. I'm going to be amending Mr. Avery's terms and conditions of probation to require him to have drug testing every 2 weeks from, where is it? So, and I think it is clear that Mr. Avery has not taken seriously these proceedings. I think that it is clear that Mr. Avery has elected to try to signify his lack of concern about the county ordinances and this lack of concern about being in compliance, and indeed his willing and active attempts to defy the sentencing order that he's under in ways that he thinks he can get away with. After the trial, after Mr. Avery's initial trial, I attempted to craft a sentencing order that was both fair to Mr. Avery and fair to the county and the need to enforce the code. I set it up where Mr. Avery had very clear parameters and very clear consequences for not being in compliance. And I had hoped that the very clear consequences would provide Mr. Avery with sufficient motivation to not be in violation of the county ordinance. Instead, it appears that Mr. Avery has tried to fashion ways that he can violate the clear intent of the county ordinance and then argue on some clever basis that he is not in violation of the county ordinance. I'm going to revoke Mr. Avery for a period of 30 days. And when he is released from the DeKalb County Jail, he will be subject to drug testing every 2 weeks. And he will again be under a requirement that he not violate any laws, just like any other probation, and specifically that he not violate the county ordinance. And if code enforcement or probation feels that Mr. Avery is in violation of county ordinance or any other laws, they can bring another petition and we'll have another hearing. That'll be the order of the court. Take the defendant into custody.
I'm probably the one that had this right.
Judge, we understand the order of the court. May we proffer 2 additional conditions of the revocation, Judge?
You may.
Thank you, Judge. Judge, we would proffer 2 additional conditions of revocation. One, that fines be imposed against Mr. Avery for the period that have been suspended, Judge, up to this point. It's clear that from Mr. Avery's behavior outside and arguably inside court, Judge, that he refuses to abide by probation. And Judge, we think that the imposition of the fines that the court graciously suspended against Mr. Avery for compliance, we'd ask to be imposed. Judge, the other condition is that we would ask that Mr. Avery be ordered to submit to a mental health evaluation and any treatment, or a psychological evaluation and any treatment deemed necessary, Judge.
Senator, we have already had the mental health evaluation. He has come back confident. That, in fact, was in reading, and I know that Mr. Kemp does not have, is not privy to that. I do not think mental health evaluation is called for at this point in time. I think that the other issues regarding whether or not he tests positive for any sort of drug use, he still needs to be here while we're.
Hold on. He's still got to be present. The defendant's still got to be present.
Yeah, we're not done. He can't go yet.
Yeah, just hold on. Just hold on.
I think as evidence
Yeah, you just hold him right there. That's fine.
in the report at this point in time, I do not think a mental health evaluation.
Put the hearings, let's make sure he can hear, so let's put the sound.
He's got to put it. Here. You can, does it need to go up or down? I don't know how to.
Put him in my hand.
Did it feel it? Can you
I'm here so
control?
far.
Okay.
I'm not taking milk from a baby.
We would object to the mental health evaluation. In regard to the fines, the court is already sentencing Mr. JV to 30 days.
I'm not going to impose fines at this time, and I'm not going to order a mental health evaluation. I understand, Mr. Kemp, but I'm
gonna appeal it straight to the higher power, take it up with him.
He's going to go spend 30 days as a guest of the sheriff, and if there's other violations, we'll come back.
I'd be praying to God in heaven that the police
And
jail,
at this
because they're
point,
not
Your
going to
Honor,
heaven, they're
I
not allowed
am
anything to say
my
about
office
it.
no longer
Unfortunately, I do
represents.
not believe in any hell.
There
would like
is
to
not
see
any statutory basis for our representation.
Just about to grant your motion.
Thank you, Judge.
I have it in my bag. I'm going to write in something on it, and then I'm going to give it to you.
Thank you, Judge.
All right.
Do you understand that?
I didn't hear no to be talking to them. That is my opportunity to be talking to them.
30 days,
I understand. I'm probably 4 weeks.
Drug-
When
drug tests by
you do
probation.
your own intervention, that means you don't have
We're
to.
not representing you anymore.
I understand that.
He's not putting fines, not putting any fines, no fines,
They're fine.
and no mental health evaluation. All right,
And we're back to where we started.
that's what he said.
Is this his piece just here?
Take this off, please.
Is what, those aren't his, but he does have.
Your name's in.
Yes, sir.
Hearing aids.
Well,
It's back. Stuff I need is back.
on this issue,
Okay. But those have,
Want me to get stuff out the back when I get there?
his hearing, you can't.
hold on. If Mr. Davis is gonna address the court, I need to have.
That's better hearing aids in there.
And Judge, there is a housekeeping matter.
Okay.
Mr. Avery is to appear tomorrow afternoon on his new citations.
Yeah.
Um,
We'll reschedule those.
all right, thank you, Judge.
Mr. Davis.
Yes, Judge McCoyd. The usual practice, of course, just previously required.
All right, hold on a second.
Hold on,
Yeah.
we can tuck those away. We're not done. Sorry. With him?
Institutionalized racism and fineness.
Can you hear us?
Yes, Judge, I'm sorry. The usual practice is if and definitely going forward, if Mr. Avery violates any probation, that we would normally produce a warrant for his arrest for a violation of probation.
That's fine.
In the event, Your Honor, because of the dynamics for magistrate court and having him appear, if that was to take place in the future, and having him to appear here, normally the inmates are not brought over to the court. I guess my question is, Your Honor, would you like me to submit a petition for a walk-in hearing or go through the normal process
I want you
of?
to go through the normal process.
Okay, yes, sir.
We'll
That I
deal
will
with
do.
where we have the hearing later.
Okay, yes, sir. Thank you.
If the normal process is to submit a application for a warrant,
Yes, sir.
submit an application for a warrant.
That I will do.
Thank you.
Yes, sir.
You good?
I believe that concludes the hearing.
All right.
Ladies and gentlemen, y'all will wait on me. I'd love to speak with them. And if you want to wait outside, I'll come out and meet you. No, sir, you're not waiting on me. I'm sorry. No, sir, you're not waiting on me.
Where did Ms. Bernard get to? Where did Ms. Bernard get to?
I know she is, Mr. Lester, with me.
Well, somehow I feel like it may not be the last time I see her.
Judge, while we have the clerk here,
Yes.
can we take up something for tomorrow afternoon?
Yes.
So this is.
We have a consent agreement which we are crafting with a Memorial Inn, and it will not be ready. But it's ready in principle, it just needs to be mocked up. We said Memorial Inn for, say, 2 weeks, I think.
Yeah, that's fine.
The 27th, thank you.
That's fine.
Okay.
This is, we're talking
Well,
about.
in the
Looks
dark.
like a,
This man is a whole month.
Things in my head.
right? Solicitors?
Yeah, it's been here for months. I think it's time.
Mr. Quinones, so I understand you're saying you can't pay it today?
Yeah, I thought 250 was a total, I didn't
Nope.
know double.
No, it doesn't quite double, it's 40%, not 50%, but,
But,
yeah, almost, but not quite, so it doesn't double it. So hold on just a second, all right?
He informed me that he's put several part-timers.
Why can't I get this? No, what's going on here?
James Avery.
Where is? I can't pull this up, is there, can you, I'm sorry, no, I'm not sure. I'm sure it's something I'm doing wrong, but.
Maybe we had a problem earlier. And
It's not.
No, we had a reboot earlier. Let's see. Something going on with the chart. What's it?
Oh, okay, good. People see they come on. Oh, they didn't actually.
Right, let's go down.
Probably 50-something citations. We can use that for the 27th. That'd be great.
Which one? It's been a while. Let me get,
I'll tell you what I'm gonna do is I'm gonna reduce the fine to $100. Can you do that on?
yes.
Okay, just reduce the fine to $100.
To 100?
Yeah, and that'll be
Okay.
enough, or you'll be able to go pay.
Okay, reduce it to 100 and you will pay it?
Yeah.
Okay, so let me get this.
All right, so what I'm gonna do is I'm gonna reduce the fine to $100, in light of the fact that the city of Atlanta has elected to make misdemeanor possession of marijuana not an arrestable offense, and they have lowered their fine to $75. I'm gonna reduce the fine to $100, which is in keeping with, the practices. Wait a minute, it's gonna be reduced to $100. There will be some costs associated with it, but you should be able to pay it today, all right? Just have a seat. I believe that concludes the hearing. I'm gonna stop the recording.